Ms. Gerler here?
She's on the phone.
No, she's on the...
I do not know how this got muted again, Your Honor. I believed I was on unmute. I have been present.
You're good right now.
Okay.
All right, where are you folks in regard to this case? Did you receive a copy of her answer?
Yes, I did. Yes, I received it on the 13th. So I'm the owner of the home at Way, Dexter, Michigan, where the defendant is now occupying the first floor. I'm very nervous.
This courtroom starts quiet, but the tension is already there. What seems like routine procedure quickly turns into a lesson about boundaries, authority, and consequences. Stay with it, because every word from the bench matters more than most people realize.
In this setting, so that's why I wrote everything.
That's okay, me too. Go ahead.
Okay. I'm seeking possession of my property, and I want the defendant to move out immediately. We have no lease. On September 23rd, 2021, the defendant and I made a month-to-month verbal rental agreement, and she agreed to pay $995 a month on the first day of each month following the first payment. On October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay.
A 30-day can't be the subject of a non-payment of rent action.
Okay. So.
All right. Do you want her to move, or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move, or do you want her to pay you?
I want her to move, and I want to also have a money judgment. So I can do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back that she owes me as of December 1st, 2023, which is $11,995 plus court costs, $215, and service fee of $68.
So how much is your
so the total money judgment requested from the court is $12,278.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated. Didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. I no longer have a vehicle. I cannot use cell phones smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute, since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know, something changed and was not necessary. But
What incorrect paperwork? I don't have a notice to that.
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well,
Ma'am, hold on. Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
Yeah, I actually see what Judge Barr is saying right now. Well, you filed 2 different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed 2 different ones, but you got, it appears to me, the correct paperwork. All right.
Your Honor, just to respond, that's what I heard from the judge. And my legal
but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I was waiting on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And
so when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And my situation is not a good one because of chronic illness. My energy is not reliable, and sometimes 12 hours in the bed.
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises back, and I have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income, the house line.
Okay, ma'am. Here's what I'm going to do, because this has got to. I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You've raised some issues in your answer, but I'm going to set it for a yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So,
they know more. They know more than us here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. Ma'am.
I actually called the zoning person too.
Okay. And she said, yeah, probably she agreed.
Right.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay. She went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out.
ma'am, I don't know. You guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm going to do. I'm going to set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote from me.
Then I don't know how I'm going to get you into court.
How is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come today. This is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used Ethernet.
All right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time, and my preference is
Okay, look, folks.
yeah.
There are a lot of folks out there that are
Everyone
having a
has
hard
sad
time,
story.
and I get it.
Yeah.
Okay, I have to deal with it every Friday, so I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you have any objection to her? What?
Tomorrow, sooner the better.
I'm not coming in on Saturday. This is not happening.
How about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh, no, I can't do 1 o'clock. What time, seriously, can I do? Non-jury trial, December 20th, 2023. 9 a.m.
9 a.m. Okay. And
You need to appear in person. Ma'am, you can appear via Zoom.
right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right. Thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
Bless you. I will sign off now.
All right. Lakestone Apartments versus Leslie Lewis, recall. Where's Miss Lewis? She's not here.
Bond violation where we asked the court to hold bond and issue an immediate warrant report to do so. I checked XGL. He's not in custody. I don't see him present. I have no idea where he is.
All right.
He's here, Your Honor.
Is he here? Where is he? There. You need to come up. I'll call your case. Court calls the case of People versus Common Creditor.
Morning, Your Honor. John Vincent on behalf of the defendant who stands to my right.
All right.
Say your name. Come on, Carter.
All right. We're going to deal with the bond hearing first and then decide if we're going to go with this case.
Okay. The people issued, sent in that motion because I had spoken to the victim myself. There was 3 police reports made, 1 made to Romulus Police Department and 2 made to the Wayne County Sheriff's Office. I'm still awaiting the police reports from the Wayne County Sheriff's Office, but I received the Romulus Police report and attached it to my emergency motion. There was texts and things that were said by the defendant threatening the life of the victim. When I spoke to her on the phone, she said she was extremely concerned for her safety, and I shared those concerns, which is why I filed a motion. I'm not sure why Mr. Carter has not turned himself into this warrant and I would ask that the bond to be set at a very high rate, determined by the court and or to remain one vote. These are 3 different violations of bond. He also has he has the no contact, he has the no go to that we have in this case, and so I don't understand what the reason that he needed to reach out for any reason.
Mr. Vince.
Well, Your Honor, is the witness here? Because that is all, and I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. He absolutely denies the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged...
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well...
Does he want a hearing on the bond violation?
Absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. And I'm also waiting for the actual screenshots of the text messages that are written in the Romulus Police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
In that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report.
I did. Before I revoked your client's bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m., he began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, then generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Well, if that's the case, then shouldn't this have been a little higher priority? I think the prosecution knows that this is not accurate. There's just simply, there's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report that says witnesses, none. Wait a minute, he's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Without a witness, without some shred of physical evidence, there's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pretrial where he's charged with child abuse sport. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots. Well, I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
wait, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. Ms. Kirby, you may continue.
Thank you. I also explained in my motion that the Romulus police report is different than the 2 other contacts that this victim had with the sheriff's department. I've included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked and he to be remanded. Given the seriousness of this case and the seriousness of his other 2 cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out with no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of, the location that she does not want me to share out loud. I have no problem sharing that with the court, but she is not present, and regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing. Thank you.
Anything else, Mr. Benson?
And if hearsay allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Keaton's is not here, but if I look at what's in here, first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to bond violation. So that maybe we can clear that part up, because so they don't need her here for that. As to the final settlement conference, the people have stated to the court that they can proceed without her, if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a
That's not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why wouldn't he turn himself in between the time I revoked his bond and today?
Just gonna come out to court.
Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm sorry. I mean,
Way the wrong answer.
I'm sorry, man.
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant remanded. Take you. Court's going to stand in recess. Maybe seated. Yeah. Can you bring him? Somebody back there with him? No. Can you bring him out? Court calls the case of the people versus Common Carter. Recall.
It was going to have to
Now, Vincent, on behalf of the defendant. There was absolutely a mix-up. And as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have come in. Yeah, it's absolutely a mistake on my part.
Well, it's not a mistake. It's a sanctionable offense. And I think you ought to know that. To willfully tell a client or even intimate to a client that they should in some way disobey a court order.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week and that you come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor, this is a horrible mistake and I'll fall on my sword for it, but it is a misunderstanding. It's not any in no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week and that he was free to come here Friday. We clearly had, at no point did I ever advise Mr. Carter to do anything else other than follow the law. And I must have told him that a dozen times, something that every time I've talked to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part, and I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working on another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then too. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, the court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant Remanded.
Yeah, my echo.
I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
And by the end of this hearing, the message couldn't be clearer. The court may listen, but it will not tolerate repeated mistakes. Sympathy only goes so far, and ignoring clear instructions always comes at a price. What's your take on this ruling? Drop your thoughts below and follow for more real courtroom breakdowns.